Yes, Mr. Hill. My lords, my lady. I was dealing with application and whether or not a passage plan is essentially an attribute of the vessel. I was going to give the court a series of examples, and the next one I was going to deal with, which I've already partly dealt with, is route. And if I can ask the court to turn up again, the passage plan in this case, which we'll see at page 252. If one turns to, sorry, I do apologise. Actually, yes, if one turns to, let me take it by, actually, if I can take you to 222. This is the actual passage plan in our case. And what you'll see is there is a series of waypoints, lat long positions and distances covered. And these set out the actual course of the route that the vessel is going to follow. And this is in the written document. This is in the written pro forma passage plan. Now, if that route takes the vessel over a shoal area, such that she will ground if she goes over that area, the passage plan is defective. If that route is also drawn on an otherwise perfectly correct chart, why is that chart now defective? We say the chart is not defective. It is the navigational decision as regards the route that is defective. And in that regard, can I ask the court to turn to the decision in the Hill Harmony, which you will find in tab 73, which is at page 1143. Now, that was a charter party case, I accept. The Hague-Visby rules had been incorporated into the charter. Owners sought to rely on Article 4, Rule 2A, errors in navigation and management. Now, it's worth looking at how the case was argued by counsel for the ship owners, who happened to be my Lord Hamblin, when he was at the bar. And if one looks at 1145, you will see, hopefully, toward the bottom of the page, between G and H, the submission, a decision taken before the journey commences, which has the effect of making the subsequent navigation unsafe, can amount to improper navigation, and a number of cases are there cited. Now, it's worth looking at how that submission was dealt with by the House of Lords. And if one goes to Lord Hobhouse's speech and starts at 1162 in the bun, what Lord Hobhouse does here is he cites the SS Lord, and he cites D, Justice Bell, judgment, the deliberate choice while in harbour of one or two routes, an error in the management or in the navigation. There is no doubt sometimes great difficulty in drawing a line between what is navigation, but I think the line ought to be drawn in a way I have indicated, and as excluding the deliberation by the master in port regarding the route by which he will nation. Now, there the temporal point is being taken about whether you make a navigational decision in port or whether you make it whilst navigating. And Lord Hobhouse says, the decision was no doubt correct, but the reason is certainly of the decision cannot be determined by where the decision is made. A master, while his vessel is still at the berth, may on the one hand decide whether to tug to execute the manoeuvre while leaving, or whether the vessel's draft. And on the other hand, the former come within the latter does not. Where the decision is made does not either conclusion. And then if one reads over the page at 1163, just taking it right at the top at A, what is clear is that to use the word navigation in this if it includes everything which involves the vessel through the water, is both mistaken and unhelpful. As Lord Sumner pointed out, where steamship is incorrect, choices as to the speed, steering of the vessel are matters of navigation, as will be the exercise of laying off a course, chart, all exercise navigation. But it is erroneous to reason, as did from the fact that the master chose how much of a safety margin he should, a hazard, or what speed to proceed up a hazardous channel, to the conclusion that all questions of what route to follow are questions of. What we say is that this part of the speech draws into stark relief what we say in this case, which is a navigational decision is a navigational decision is a navigational decision. It doesn't really matter whether you take it in port or you take it as you're steaming. If it is a navigational decision, it's not an attribute of the vessel. Now, I'm going to go to a second example. And this example is if one considers pilot-master exchange. Now, I'm sure the court will know a pilot has local specialist knowledge. He or she is employed by local pilotage associations, but in law is an agent of the carrier, even where the pilotage is compulsory. A pilot-master exchange is a necessary exchange of information between the master and the pilot before the vessel is navigated from the port. It happens before the commencement of the voyage. Now, this is a critical aspect of passage planning in general navigation, and it's set out in some various IMO guidelines. It's set out in the guidelines we've looked at, so I won't go back to them, which is at page 299. But it's also set out in another set of guidelines, which we sent to the court. I don't know if the court has them. It's the IMO recommendations on operational procedures for maritime pilots, Annex 2. We sent them to the court. We've got hard copies here if you've not been provided with it. It was sent, I think, last week.
I don't remember seeing it, I'm afraid, Mr. Hill.
I do apologise.
No, it may not be your fault.
Would the court like us to hand them up?
Yes, that would be helpful, thank you.
I have got it on my file.
Yes, I've got it.
It's 960 brackets 23, right?
Um,
I think I'm looking at the right document.
Yes.
We didn't understand it had been put into the bundle. It should be, the IMO guidelines on operational procedures for maritime pilots. Right. And if you go to Annex 2...
I'm sorry, is Her Ladyship saying 960?
Yes, it's called in our listing, Clean Resolution.
Ah.
Yes.
Yes, I do have that. Oh, yes, we do have this. Thank you.
Oh, great.
Yeah.
If one goes then, I'm sorry I don't have the page numbering, but if one scrolls down, there are two annexes. And if one goes to Annex 2, you'll see recommendations on operational procedures for maritime pilots. This is an IMO guidance. And if one keeps scrolling down to 5, Master Pilot Information Exchange, and one sees paragraph 5.5. So what happens is the pilots come on board before you leave port, and you're supposed to have a full master pilot exchange for the purposes of making sure the navigation under pilotage is correct and that the right decisions are being made. And it says, it should be clearly understood that any passage plan is a basic indication of preferred intention, and both the pilot and the master should be prepared to depart from it when circumstances so dictate. Now, the absence of a proper pilot-master exchange, for example, on how and when tugs will be used during an unberthing process, will involve defective navigational decisions. On the logic, we say, of cargo interest case, a failure to undertake a proper pilot-master exchange before the commencement of the voyage is a defect which a prudent owner would insist was remedied had he known about it before sending his ship to sea. We say it cannot be right to say that the ship was automatically unseaworthy because an exchange as part of navigation was not conducted properly or at all. It's simply an error of navigation, even though it happens before the commencement of the voyage. We obviously accept that if the pilot-master exchange did not take place because the master did not know one should take place, or because his SMS systems on board the vessel did not require one, then the vessel is unseaworthy. That's because of crew incompetency or lack of proper systems. It's not because the mere fact of not having a pilot-master exchange renders the vessel unseaworthy. Now, at this point, I'd like to take the court to a US decision which makes some of these points as well, and it's the Jalavihar decision, which the court will find in tab 96 at page 1621. Now, this is a decision of the Court of Appeals for the Fifth Circuit, and it's a 1997 decision. For your notes, we discuss it in our written case at paragraph 95. Now, the facts are straightforward. While executing a routine turning manoeuvre in the port of Mississippi, in the river of Mississippi, the Jalavihar grounded. And one of the questions for the court was whether the master's failure to discuss the manoeuvre with the pilot prior to the commencement of the voyage rendered the vessel unseaworthy, and the Court of Appeals concluded that it did not. And all we ask you at this point is to turn up 1627. And reading from the top left-hand column, Euseminas, that's the cargo interest, initially argued that the master's failure to discuss the manoeuvre with the pilot was an unseaworthy condition, which caused the grounding. Scindia, that's the owners, however, correctly states that in Avondale, a panel of this court found that the master's failure to adequately discuss the manoeuvre constituted negligence on the part of the master. Any negligence of the master concerning the movement of the vessel would be considered a navigational or managemental error, not an unseaworthy condition. Euseminas' response to this argument is that Scindia's lack of company policy requiring the master to discuss the routine manoeuvres with the pilot constitutes an unseaworthy condition. And then he goes on first, however, Euseminas must show that the district court was incorrect in rejecting the failure to discuss as a cause of grounding. The point we rely on there is that having a pilot-master exchange is all part of passage planning. It's all part of navigating the vessel. As I showed you from the IMO regulations, your passage plan is nothing more than a basic intention. It can change. It can change after you've discussed matters with the pilot. These are all seen as navigational decisions, and they don't render a vessel unseaworthy because it's essentially not innate to the vessel. It's not an intrinsic quality of the vessel. The vessel remains navigable, but there's just an error in navigating. I think it's a final example I want to give, which is to consider what the position would be when a passage plan is amended or updated. We say because a passage plan is no more than a basic indication of preferred intention, it's subject to constant review and amendment by the master. And I took the court to the IMO guidelines earlier about amendment this morning. As we've said this morning, there are 4 stages to passage planning: appraisal, planning, execution and monitoring. And all 4 stages of passage planning involve navigational decisions by the master and deck officers. If the master's navigational intention changes and the passage plan is revised during the voyage, and this causes the vessel to ground, it appears to be common ground that the change in intention is there, and therefore the revision of the plan constitutes an error in navigation for which the carrier is not liable. What appears to be disputed is whether such a grounding was also caused by the vessel being unseaworthy because the passage plan becomes effective. One reason this cannot all turn on cargo interest temporal distinction is that it would have to work in cases where the obligation of seaworthiness is continuing. So if you've got a continuing obligation of seaworthiness, for example, under the Shell Time 4 Charter, if a master at sea changes his passage plan from being a good passage plan to a defective passage plan, it would inevitably, on my learned friend's case, cause the vessel to become unseaworthy. And we say, on my friend's case, my learned friend's case, the vessel is slipping from being seaworthy to unseaworthy and vice versa, depending on whether there has been a change in navigational intention and potentially on whether that intention has been recorded in a document. We say that cannot be right. Navigational decisions essentially highlights that navigational decisions are not attributes of the ship. The final area I want to just explore is this whole concept about, does it matter whether it's written down in a document, a navigational document such as a passage plan? We say it's common ground that when the vessel is still at berth, so she's alongside the load berth and she hasn't departed on her, the master's navigational decisions as they stand must be recorded in a passage plan document. And we accept that, and it's the IMO regulation. It also appears to be common ground that it doesn't make any difference that the decisions are written down in a document. On cargo interests case, if the master decides when at berth that he will take some action during the anticipated voyage, and that action will imperil the vessel, on their case, the vessel is unseaworthy. It doesn't matter whether or not the decision has been written down. Why do I say that? That's because they apply what's called the prudent owner test, that Fadden test. And they ask, would a prudent owner send his ship to sea if the master had taken a decision, that decision, or formed that intention? So it's just an application of the prudent owner test. Cargo interests say that any defect will do. It doesn't need to be an attribute of the ship. And in fact, in a blog post made by cargo interests after the Court of Appeal decision, they say that the master's intention alone arguably makes the vessel unseaworthy. It's worth just looking at that. It's at page 1975. And taking it, it's 1975 out in the middle of the page. This is a commentary on the Court of Appeal's decision. More interesting, perhaps, it's sentenced in the penultimate paragraph. More interesting, perhaps, is whether defects in passage planning which are not recorded in any document can make a ship unseaworthy. What if the master has an intention prior to the commencement of the voyage to navigate in a way which exposes the ship to danger? If there is no requirement to identify any attribute, the master's intention arguably makes the ship unseaworthy, although there might be difficult questions as to whether that prior intention is positive. Another possible example, considered in the course of argument for the Court of Appeal, is if the SMS, the safety manual, requires a master pilot exchange to take place at departure. It would appear that the fact that no such exchange has taken place is capable of constituting unseaworthiness. These are all the problems that one has thrown up by the Court of Appeal's decision below, which are essentially that navigational decisions can render the vessel unseaworthy. Navigational decisions can render a vessel, if navigational decisions can render the vessel unseaworthy, essentially, what does it matter if they've been written down or not? owners also say that it doesn't make any difference that the decision is written down in a passage plan. But the reason we say it doesn't make any difference whether it's been written down in a passage plan or not is because the decision retains its character as a navigational decision, as I showed the court from the speech of Lord Hobhouse in the Hill Harmony. Now, I want to deal with one last matter, which is my learned friend's submissions in their written argument that a passage plan is a navigational tool. And they deal with that at paragraphs 82, 89, 111 and 160. And they say a passage plan is a navigational tool, just like a chart or a compass. Now, we say the term navigational tool is an inaccurate label. The passage plan is a set of navigational decisions. It's not a tool that is used by the crew to make those. I'll just make that a point again. The passage plan is a set of navigational decisions. It's not a tool that is used by the crew to make. So a passage plan is not equivalent to the equipment provided by the carrier to the crew in the same way as, for example, a compass is in the Thordock case, that my learned friends rely on, or a radar or an echo sounder. It's also not equivalent to a published chart or now these days in 2021 an electronic chart display on your vessel. It's the end product. The passage plan is the end product, not a tool used to assist in producing that end product. And this distinction is recognised in SOLAS, which I took you to earlier, where the SOLAS regulations make it clear that the carrier has to put on board all the charts, notices to mariners, all the publications, and then it's the master in Regulation 34 who actually has to do the passage planning using all of that equipment, i.e. the navigational tool is the equipment the carrier gives. The passage plan is not a navigational tool, it's the result of navigational
Well, can the carrier give instructions to the master?
Sorry?
Can the carrier give instructions to the master about what he shall or shall not do with the passage plan? I thought that it might follow from the two conventions you showed us this morning that there was no question of that.
No, he shouldn't. He should not say, the carrier should leave it entirely to the master to plan his passage, and he should leave that discretion to him and should not interfere. And I'm going to take the court to some more decisions on that when we get to due diligence, because this straddles the two grounds of appeal, because it's also relevant to the due diligence aspect.
Well, it may be also relevant to the interpretation of the conventions, if that was the position in 1924. Correct,
and it is.
Can I just express a doubt as to whether the approach you're following is the most apt. The problem here arose from the fact that the master did not follow the passage plan. And the aspect which the judge criticised was that a navigational tool, which was the chart, had not been annotated in a way which would alert the master during the voyage if he was considering whether or not to depart from the passage plan to a potential risk.
With respect, we say that's not the correct analysis. We would say the navigational tool is the published chart. The navigational tool is also the notice to mariners that contain the depth warning. Those are the navigational tools. In fact, the navigational chart says, read the notice to mariners, and it actually has a printed statement. Read that. What happened is that as part of passage planning, the judge said, well, you should, having read the notice to mariners, as a matter of navigation, you should decide you don't want to go out of the fairway. Now, he says, and I think it is 67, paragraph 67 of his judgment, but I'll have to check it. You could hatch the chart to say, don't go out that way. Don't go outside of the fairway. But there was a debate about whether that would make the chart too busy and make it difficult then to use during the navigation. And the judge chose to accept some evidence that another way of dealing with it would be to write the warning at the top. But the writing the warning at the top, my lord, we say writing the warning at the top is part of passage planning. You've got all the tools, your navigational tools, as part of just laying off your course, as writing the speed in a channel, as part of hatching and say these are no-go areas. Another navigational decision would be to write at the top, be careful, depth warning, can't rely on the charted depths. It's not the tool. The tools to be used were perfectly adequate, were proper, the chart and the notice to mariners. It's how he used those tools in navigation. Now, cargo interests rely on the fact that the passage plan is used by the crew during the voyage. They say that the annotations on the chart are used by the crew in the same way as the other information on the chart. That's actually the point my lord's just made. But this statement, we say, ignores what those passage planning annotations are. An annotation, for example, to do 6 knots in a channel or to follow a certain track, is a set of navigational decisions which, for the most part, are replicated in the passage plan pro forma document, which I took you to earlier, the actual written document. They tell the officer of the watch what to do based on navigational decisions taken by the second officer and the master when the passage plan was prepared some hours earlier. And as explained in the Hill Harmony, when those decisions were to be taken is irrelevant. They do not lose their character of navigational decisions. The master could be standing on the bridge and decide these matters at the time, safe speed, courses and the like. It's no less a navigational decision because the master has gone through the thought process in advance and decided on the safe speed and written it down in the passage plan pro forma or in pencil on the working chart. To describe these decisions as a tool is therefore inaccurate. We say it's navigation. The navigation, and I've made the next point, navigational tool that was being used was the published chart and the notices to mariners. So I've made this. And we say, finally, because passage planning is a continuous process, it does not make sense to call the passage plan at any particular time a navigational tool. It's a living instrument and is subject to constant review and amendment.
Yeah. Paragraph 70, the judge, I'm looking at page 165, last sentence. My conclusion, having considered the expert and other evidence, is that whilst it would of course be prudent to note the warning in the passage plan, it would also be necessary and prudent to mark the warning on the chart, since that is the primary document to which the officer navigating the vessel would refer when making navigational decisions in the course of the outward passage.
Yes.
So he's talking about an inadequacy in the information available to the officer navigating the vessel during the course of the voyage.
Well, firstly, when it comes to information available, the information was all there. It's in the chart and it is in the notice to mariners. Can I just ask the court to just look at paragraph 67?
But it's all very well to say you've got this bit of information and you've got that bit of information over here. The judge's criticism, the whole point of the case that he's focusing on is the fact that those two pieces of information weren't brought together on the chart.
I agree, my lord. I completely agree. And it's the act of it's putting it on the chart doesn't mean it ceases to be navigation. Because, and I would just highlight paragraph 67. My learned friend's expert said you should actually hatch out the areas on it. That's paragraph 67. Then if one looks at paragraph 69, he considers that in 68, and at 69, sorry, in 67, then in 68 he considers an alternative approach. In 69, at the end of 69, he says, I'm not persuaded that the only way in which a passage plan could have been prudently prepared in this case was by means of hatched lines in pencil along the entire length of both sides of the fairway. And then he says, nevertheless, prudent passage planning required the danger created by the presence of numerous depths less than those charted outside the fairway be noted on the chart. And then he considers that the best way, having heard the expert evidence, is to write the warning on the top of the chart. But that is a warning that is being written by the second officer of the master on the top of the chart in the course of preparing for navigation, which is preparing a passage plan, which is navigation, so that when they're navigating, they have that information. And it's essentially an easier way than actually having somebody standing on the chart, by the chart table, reminding the master or the navigating officer what the notice to mariners says. But that doesn't mean it's now lost its character as being navigation.
Yes, but if you think about the reality of the situation, when a ship is travelling down the fairway, in this case, the captain obviously had his reasons, the master had his reasons for leaving the fairway. One can imagine a whole variety of circumstances that might occur,
yes,
which might make him consider leaving the fairway, and that's why we're told it would be necessary to mark the warning, because that's what he would look at. It's that chart he would look at when making navigational decisions, which would involve a departure, obviously, from the passage plan itself, if he was contemplating leaving the fairway. That's the chart he's going to look at in the course of the voyage, and it's because, on the facts of this case, it's because he's liable to consider leaving the fairway and therefore entering the danger zone, that the existence of a danger ought to be information which is readily available to him on the primary document to which he would refer.
Yes, and what we say is that is all part of passage planning. We say that thought process is all part of passage planning, and annotating the chart so that you navigate in that way is all part of passage planning, and it doesn't lose its character as being navigating and passage planning. If I go back to the bargain struck at the conference back in 1924, the bargain that was being struck is cargo interests accepted that to get their Article 3 obligations on owners, namely seaworthiness and bailment obligation to care for the cargo, they accepted as a quid pro quo that cargo are responsible and will insure for errors of navigation. And we just say, yes, our master made a mistake, and I don't go behind the facts of this case. He made a mistake, but that was an error in navigation. And if this court, and if the courts now start moving decisions and acts of navigation earlier in time into concepts of seaworthiness, you upset that bargain that was struck.
Thank you very much.
Okay, I'm going to move on to my final topic, which is due diligence. I may go. I was going to stop at 3 o'clock and give myself an hour in reply. I may use up 5 or 10 minutes of my reply and move on.
That's a matter for you.
I'm grateful. We want to first deal with one important preliminary point. Cargo interests recognise that their approach to seaworthiness leads to borderline cases. And I don't know if my lords and my lady, remember that from my learned friend's written case at paragraph 156, they consider the Apostolis and the Captain Sakharov, and they say the two are inconsistent, like Mr. Justice Flo did in the Court of Appeal. They say that those cases are at the extreme edges of unseaworthiness. These are cases where cargo can cause the vessel to be unseaworthy. And they say they are responses to the problem which arise when something dangerous is placed on board the vessel. Now, we don't agree that those cases are problem cases at all, but we can park that for a moment. What we do agree with the cargo owners about, cargo interests about, is that there are essentially two ways to resolve problem cases. Cargo interests at that paragraph 156 say you can either say the dangerous cargo, for example, is an attribute of the ship, or if it is, you either say it's not an attribute of the ship, which is the apostolis, or if it is an attribute of the ship, the loss resulting from such dangerous cargo is out with the orbit of responsibility of the carrier for the purposes of due diligence, which is the captain Sakharov. Their case at paragraph 157 is that the approach in the apostolis based on seaworthiness is wrong, and that the better way of addressing the issue is that undertaken in the captain Sakharov, both Court of Appeal decisions, and you look at due diligence. Now, we disagree with them on their analysis of the apostolis, but we agree with them that there are two ways in which the issue can be addressed. So the problem raised by a defective passage plan can, we say, similarly be addressed in one of two ways. The first is to say that those navigational decisions are not and never become an attribute of the vessel, and therefore defective navigational decisions do not render her unseaworthy. That's our first ground of appeal. But our alternative ground of appeal is that even if they can amount to a defect in the vessel when written down in a passage plan or on a chart, because, well, a passage plan chart is, of course, part of a passage. They remain decisions made by the master, who is singularly and exclusively responsible for navigation, so that they are out with the orbit of responsibility of the carrier, and the carrier has discharged its obligation to exercise due diligence, so long as it provided a competent crew with everything they would need to passage. And that's essentially our second ground of appeal. For due diligence, we put forward three key propositions. First key proposition is, and they're set out in our roadmap, is that the critical question in each case is whether the carrier has taken all the requisite steps to discharge its contractual obligations to exercise due diligence. And we say, importantly, this is not the same as asking whether due diligence has been exercised by anyone and everyone, which is how cargo interests put their case. The second key proposition is that the steps required to be taken to discharge the due diligence obligation depends on the specific aspect of unseaworthiness. Now, by contrast, cargo interests seek to adopt a one-size-fits-all approach and ignore the particular aspect of unseaworthiness. But we say the case law shows that the law is developed incrementally and that the steps which the carrier has to take to discharge its due diligence obligation varies depending on the aspect of seaworthiness and the nature of the defect. This means that the steps which are required to be taken by the carrier to discharge his obligation do not necessarily cover all steps involved in the relevant aspect of seaworthiness. Then finally, the third key proposition is that applying the critical question to passage planning as a specific aspect of now unseaworthiness, a carrier will discharge his obligations to exercise due diligence under Article 3, Rule 1 by properly manning and equipping the vessel such that she can be navigated safely, including by providing proper instructions and auditing that those instructions are being followed. And we say another way of putting the same point is to say that the function of passage, unlike equipping the vessel with all that the crew needs for passage, the actual function of passage planning itself is outside the carrier's orbit of responsibility. And if one looks at the cases,
so does this argument apply to negligent management as well?
It is very difficult to see how you can have a managemental decision that hasn't led to a defect in a vessel which is an attribute of the vessel, which isn't an attribute of the vessel. Sorry, which is an attribute. So can I put that in a better way? We've also thought about this question a lot. We can't think of any situation where a managemental decision that doesn't end up resulting in being in a defect in the vessel, which is an attribute. What we say is navigation is peculiarly, singularly and exclusively for is for the master and is not a responsibility for the carrier. So I don't want to dodge the question, but we would say you don't have to decide that today. We can't think of a scenario where it would come up. Now, although the language used by the judges in the case law differs, and they say orbit of responsibility, or they talk about the carrier's control functions and responsibilities, or whether something is being done in the capacity as carrier, we say it's analogous to essentially the scope of duty in the Samco line sense. The question on which this appeal turns is, in short, whether in a case where there was nothing more the carrier could have done, the risk of a defective passage plan has been assumed by the carrier as opposed to the shipper. Now, turning to the first proposition, what is the critical question? Again, it's common ground that that lack of due diligence is negligence. So under Article 3, Rule 1, lack of due diligence is negligence, and therefore liability is fault-based. Cargo interest case is that the carrier is responsible for anyone's negligence because the obligation of due diligence is non-delegable. And as we've explained in our written case, we say the concept of non-delegability is probably a misnomer in this contractual context. The correct analysis is one of vicarious performance of a contractual obligation. The carrier is entitled to discharge its contractual obligations to the shipper by arranging for a third party to perform, because the carrier's personal performance is not of the essence. At the same time, the carrier cannot avoid its contractual duties, and it remains liable for any failure by third parties. So we say the Muncaster Castle, which is the big case dealing with this, follows from an application of these entirely orthodox principles. It did not matter through whom the carrier chose to discharge its obligations to exercise due diligence in that case. The carrier remained liable for the failure to do so. We say the reason that decision does not provide an answer to the present case is because the critical question for the court is what a carrier has to do to discharge its obligations to exercise due diligence. And then we say, as can be seen from the Anglis line of cases, the carrier in certain cases discharges its obligation by diligently supervising work, but does not necessarily warrant that work has to be done diligently. And we say once this critical question has been answered, it follows from the Muncaster Castle that it does not matter whether the carrier chooses to discharge the contractual burden through an employee or a third-party contractor. So it's not about the Muncaster Castle, essentially. Cargo interests articulate the critical question as follows. They say, the relevant question is, who the owner has employed to ensure the seaworthiness, or to whom has the carrier delegated its obligation to ensure this aspect of seaworthiness? And that's paragraphs 164, 167 of their case. We say that's not correct. For example, in Anglis and the Happy Ranger, plainly the employer the owner employed shipbuilders to ensure the seaworthiness of the vessel. That was not the end of the analysis, though, and the carrier was not liable for the shipbuilder's negligence, even though the shipbuilders had been employed by the carrier. Similarly, language of delegation presupposes that there was something for the carrier to delegate. In the Captain Sakharov, one reason why the carrier cannot be said to have delegated the task of stuffing containers is that it's not within his scope of his duty. Or more simply, it's not a risk against which the carrier has to insure itself. Now, in this regard, the Court of Appeal, in this case, adopted the non-delegability approach, which is the same approach cargo interests asked the court to endorse. The Court of Appeal below asked, and I'm quoting from paragraph 99 of Lord Justice Mayles', that it has to ask itself whether owners could avoid liability by delegating responsibility for making the vessel seaworthy to the master and officers. Now, with respect, we say that's the wrong question. This assumes, as we say cargo interests do in this case, that the owners had a responsibility under Article 3, Rule 1, draw up a passage plan. you've already jumped over the first step. You've assumed that it's within the the carrier's responsibility to actually draw up passage plans. In determining what the carrier has undertaken to do in exercising due diligence, we say one has to take into account the exceptions in Article 4, Rule 2, which we say inform the proper understanding of what constitutes diligence. Now, I've already explained this morning in the context of construing the Hague Rules that there's an obvious relationship between the due diligence obligation under Article 3.1 and the exceptions under Article 4.2. And I mentioned this morning, and I'd like to do it now, this was actually addressed in the Travaux, and there's agreed commentary on this. The delegates agreed a formal commentary that we can all look at to understand this relationship. And you'll see it in at page 1742.
So before we get there, the premise here is the vessel is unseaworthy.
Correct.
As a result of the negligence of the master or other deck officers.
So, for example, if the court were against me and said a passage plan is a navigational tool and the vessel was unseaworthy because...
Well, we're only getting to this stage on the basis the vessel is unseaworthy due to the acts, let's say, of the master. Is there any case where the carrier has not been liable for unseaworthiness caused by the master?
No, I can't think of one, but I think again, with respect, that's asking the wrong question. It's the negligence in navigation by the master produced a defective passage plan, which on this hypothesis we're deciding renders the vessel unseaworthy. What we say is the question then has to be asked, okay, the vessel is unseaworthy, but was it within the orbit of responsibility of the carrier to produce a passage plan?
Well, it was his orbit of responsibility to provide a seaworthy vessel.
Yes, and it's also his obligation under 3.2. We accept to carry the cargo safely, and I accept all of that. But if he has an obligation to provide a seaworthy vessel, we go back to the critical question. The critical question is, what steps does a carrier have to exercise to fulfill his function of exercising due diligence to provide a seaworthy? And those steps can either be do the job himself, so he has to produce the passage plan that's not defective. Or those steps, what are the steps he has to do, the carrier, qua carrier, are, we say, appoint a competent crew, give them all the equipment, give them all the instructions, and make sure that they're following their instructions. Those are the steps that the carrier has to take. And that's why we say the critical question is always what are the steps? If I can develop it, I'm going to come back to that in a moment, but before I do so, if I can just take the court to the commentary in the Travaux, it's at 1742. And if we can pick it up in the right-hand column, it's the penultimate, 3 up from the bottom. This is a commentary on Article 4.2. A commentary on this article was formulated fairly happily on the proposal of the English delegation, saying that there were in effect 3 major subdivisions, and this is the subdivisions in relation to Article 4. The first included the case dealing with the actual faults of the captain or the agents of the ship owners in navigational management. That is to say, technical and nautical. In such a case, there was no liability on the part of the ship owners for these faults. No liability. That was compensation for the obligation imposed on the ship owner always to accept liability in matters of cargo. The second category included a series of occurrences that could be deemed force majeure, where the ship owner was not liable. These were cases C to P. In all these cases, there was debate as to what would happen if a fault that had been committed that was the true cause of the damage produced. It was decided that a distinction had to be made. If it were a fault relevant to what was said in item A, actual fault or privity of the captain or his agents in the technical and nautical management of the ship, it could not be used against the ship. If, however, it was another fault arising from such, it could be used against the ship, just as his own personal. And then the third category is the final paragraph. Finally, in the third category, cases other than those listed already resulting in neither actual fault of the carrier or his servant or his agents. In such cases, the ship owner was exempt from liability on condition that he proved that there was fault nor privity on his part. Now, we say it's common ground that a carrier has not failed to exercise due diligence where neither its employees nor its contractors have been negligent. And that's Q. And it's also common ground that a carrier has not failed to exercise due diligence where a defect was not discoverable by the exercise of due diligence. That's P. We say this appeal turns on whether the master's error in passage planning similarly does not constitute fault by the carrier for the purposes of exercising the due diligence. Now, our second proposition, this involves looking at how the critical question is applied to different aspects of seaworthiness. And we say the law has developed incrementally, aspect by aspect, and the common law on due diligence has, just like the common law on seaworthiness, entirely properly construed the Hague Rules as a convention with international currency, and many of the decisions have been based on history, policy, and precedent. Now, if we start with hull and machinery, what does a carrier have to do to make his vessel seaworthy in terms of hull and machinery? Well, the steps to be required by the carrier depend on whether the material defect rendering the vessel unseaworthy occurred before or after it came within the carrier's possession. And the carrier is generally not responsible for any negligence by the shipyard or previous owner, so long as the carrier makes reasonable inquiries when the ship first comes into his possession. And the leading case on that is Anglis, and it's worth just very quickly looking at one part of Anglis. It's page 318, or tab 27, and if one can go to 323, just picking, in this case, the vessel was found unseaworthy because of defective workmanship during the construction. But the carrier was found to have exercised due diligence because he employed an inspector to oversee the construction. If one looks at 323, bottom of the page, halfway through the paragraph, having considered the old rule of absolute obligation of seaworthiness, Justice Wright goes on, I think that the new acts have intended to emphasize specialisation, which is the distinction of carrier and shipbuilder, to limit the carrier's obligation to due diligence in his capacity as carrier. And we rely on that, not in his capacity as quay navigator. He is to be liable for all such duties as appertain to a prudent and careful carrier acting as such. By the servants and agents in his employment. If he has a new vessel built, he will be liable if he fails to engage builders of repute and to adopt all reasonable precautions. He may be bound to require, for instance, that the builders to satisfy one of the well-known classification societies, Lloyd's, or to engage skilled naval architects to advise him, and skilled inspectors to support work. In the same way, if he buys a ship, he may be required to show that he has taken appropriate steps to satisfy him by appropriate surveys and inspections fit for the service. But I do not think in any case that a carrier can be guilty of want of due diligence simply because the builder's employees have been put in some bad work, which, though concealed, renders the vessel unfit. Now, I appreciate that doesn't answer my Lord Hamlet's point, which is, but that's somebody else. It's not the ship owner's agents, servants or agents, and I accept that. But we're going to come on to another case in that respect that helps more, which is the Eurasian Dream. And then if we look at supplying a vessel, adequate supplies, the obligation adequately to supply the ship with bunkers, for example, requires the carrier to see to it that reasonable diligence is exercised regardless of who is ultimately tasked with the object. It is similar to repairing a ship. The carrier is responsible for all steps involved in making the ship seaworthy. And the leading case for this one, adequate supplies, is a case called Northumberland Shipping and Thames. I'm running short of time, so I won't take the court to that one. But it's a decision of the House of Lords where at page 677 to 678 and also 680, the House of Lords makes it very clear that it's the obligation of the carrier to, for example, supply and bunker a vessel. And if he chooses to delegate that to the master, so be it. He's responsible for the master's acts, but it's primarily a responsibility of the carrier. Now, Mr. Justice, Lord Justice Males in the Court of Appeal relied on the EVG number 2 as a case demonstrating that owner's submissions were wrong because in that case the master had miscalculated the bunkers, and we say with respect that misses the point. The carrier may entrust the task to the master, and in the FG number 2, Lord Denning said the master was negligent. But also, can I just ask you to note that in the FG number 2, the point of due diligence was conceded by counsel. It's at the top of page 1047, left-hand column, and we say that's not surprising at all. It's unsurprising in the light of the House of Lords decision in Northumberland Shipping and Tim, where it was clearly said it's always a responsibility of the carrier. Unsafe stowage. A ship will be unseaworthy if the condition, contents, or the manner of stowage of a container are such that when on board the ship, either at all or stowed in the wrong place, it poses a danger to the ship. Now, the Court of Appeal's decision in the Kapitan Sakharov is authoritative for the proposition that the step of opening up and checking the contents of a container to ensure that they are not dangerous is outside the orbit of responsibility of a carrier. Importantly, this is not because the bill of lading holder is at fault for stuffing the containers. Often he's not. Often the bill of lading holder it never stuffed the containers at all. But it's because that is a risk which is for cargo and one that cargo have to insure against. Now, where the cases become more analogous is when one looks at incompetent crew. It's well settled that if any member of the crew, such as the master, is incompetent, then the carrier is not ipso facto liable on the basis that the carrier has delegated his obligations to the master himself. And this example gets more to my Lord Hamblin's point about cases involving the master and crew themselves. Now, for example, assume a chief engineer needs a certain qualification to get a job on board certain types of modern ships with specialist engines. He pays a training company to attend a course they run, but the chief engineer only partially attends the course and doesn't properly complete it. The training company then negligently fails to ensure his full attendance, but certifies him to be competent in the relevant skill when he's not. The training company was negligent, but its lack of due diligence is not within the carrier's sphere of responsibility, for example. One turns up the leading case on this, which is the Eurasian Dream, and one can see it at page 1016, tab 65. The facts of this case aren't particularly relevant. If one just goes straight to 1033, in the right-hand column at 1033, Mr. Justice Creswell sets out how crews may be incompetent, right at the bottom of the right-hand column. Incompetence is to be distinguished from negligence and may be derived from, and he gives a number of examples. Inherent lack of ability, lack of adequate training or instruction, for example, lack of adequate firefighting training, lack of knowledge about a particular vessel and its systems, or D, a disinclination to perform the job properly, or moving on, E, physical or mental disability or incapacity, for example, drunkenness or illness. And then if one turns over the page and looks at 1035, picking it up at paragraph 132, Miss Justice Creswell says this: if the vessel is found to have been unseaworthy due to the incompetence or inefficiency of the master or crew, it is for the carrier to show that he has exercised proper care in relation to the following: the appointment of a generally competent master, crew. That is to say, the owner's managers must have taken care to see that the master crew were suitable men for the post. The owner's managers must take reasonable steps to satisfy themselves of this. They must satisfy themselves by inspection of the seaman's documents, interviews and inquiries from previous employers, and that he is reasonably fit to occupy the post which he's been appointed. And then 2, specific competence of the master in relation to the vessel and voyage in question. It will not necessarily be enough to rely on the certificates of competence held by the seaman. The owner's managers must provide the master crew with reasonable necessary instruction and supervision on an ongoing basis in relation to vessels and voyages. Now, that second limb is particularly important for our purposes. For example, assume that there is a software update to a ship's radar equipment and a short handbook is released describing the changes that have been made. The carrier provides the master with a copy of the handbook, instructs him to read it whilst he's in port. However, the master doesn't do so and therefore is lacking critical knowledge about how the radar works. Assume that the vessel is then involved in a collision during the next voyage as a result of the master's lack of knowledge about how the radar works. The Eurasian dream shows that there would be no failure to exercise due diligence in that scenario, where the master is given the instruction by the carrier, but he doesn't read it. He's given the handbook, but doesn't read it. There's no negligence there on the part of the carrier in respect of any step which it has to take as carrier. Now, we say this cannot be explained on cargo interests approach, which would simply involve asking, to whom did the carrier delegate the task of ensuring that the master had the knowledge contained in the relevant manual, and was that person negligent? That's what they say the question is, the critical question. The answer would be that the carrier delegated the task to the master, and he was negligent in failing to read the manual. The carrier would therefore be in breach of his Article 3 Rule 1 obligation, according to my learned friends. However, the Eurasian dream tells us that this is not the correct approach.
The passage you've shown us is to do with the competence of the crew.
Yes, that is dealing with the competency, but for example, you can be not competent because you haven't got the requisite knowledge, because you haven't read the requisite manual, for example. And as long as you've given the master the handbook for the radar because there's been a software update and told him to read it, that is sufficient. You are not liable as a carrier if the master simply fails to carry out the instructions and doesn't read the handbook and therefore has a lack of knowledge. We say the same analysis applies to a master who is drunk, ill or fatigued, and therefore temporarily incompetent, as Mr. Justice Creswell suggests. We say the approach in the Eurasian dream to how the critical question is answered in relation to crew competence reflects a broader principle that certain matters are outside the carrier's orbit of responsibility. This is the important point. In particular, matters which are innate to the master or other crew members, something that is singularly and exclusively for them to do, will not be within the carrier's orbit. It is singularly and exclusively for the master to educate himself by reading the handbook provided by the carrier. It's singularly and exclusively for the master not to drink too much so that he becomes drunk. Or it's singularly and exclusively for the master to make sure he has enough sleep so he's not fatigued. These are all matters that are singularly and exclusively within the remit or orbit of responsibility of the master. And as you can imagine, I'm going to go on to say, so is passage planning. just one last point on that before I draw the threads together. So if one looks at how this is dealt with in voyage charters, one of the leading books on this, if I can ask the court to turn up page 1920, which is tab 109. You will see, we say the position is accurately summarised by the authors of voice charters. If we start at, if we're at 1920, in paragraph 8599 at the top of the page, the authors cite the classic position, the duty is not delegable, and they cite the Muncaster Castle. They say in the third line, it is a duty of due diligence by whomsoever carries out the work of maintaining or repairing the ship to a standard, whether employees or the carrier or independent contractors. However, they then say at 85-100, however, so it's a qualification to the Muncaster Castle principle. Not all failings which lead to a vessel being unseaworthy are thus attributed to the carrier. The relevant want of due diligence must be by someone performing the functions undertaking in the capacity of the carrier and not in some other capacity. Now, this goes to the point that my Lord Hamblin just made to me. Well, isn't Article 3, Rule 1 all about the carrier having to make the vessel seaworthy? But the point is this, we say. Just as it's not within the orbit of responsibility of a carrier, qua carrier, to stuff containers, and that's the example, for example, given in the Kapitan Sakharov, it's not within the orbit of responsibility of a carrier, qua carrier, to navigate the vessel. So this brings me now to the all-important question: how does all this apply to passage planning? Now, we say for most aspects of unseaworthiness, the steps that a carrier has to take are clear and they're normally a matter of precedent. And as I said, the law deals with this incrementally, and we've got a number of cases for all different types of situations. But there has been no previous case where the vessel has been found to be unseaworthy because of a defective passage plan. So the question of what the carrier has to do to discharge its obligation due diligence is entirely novel. There is no other case where this has been decided. Only's case on this appeal is that a carrier must see to it that due diligence is exercised by whomever he employs in this respect in matters within its orbit of responsibility, the carrier's orbit of responsibility. And matters within its orbit of responsibility are those of manning the ship with competent navigational officers, equipping the ship with all navigational equipment required for passage planning, such as charts and notices to mariners, compasses, electronic charts and the like, providing proper instructions to the crew about passage planning, and then supervising and auditing the crew to ensure that those instructions are being properly followed. That's within the orbit of responsibility of a carrier. However, we say the process, the actual process of passage planning itself is not within the carrier's orbit of responsibility. That is within the orbit of responsibility of the master. We say this for three related reasons. The first is that Article 3, Rule 1 must be construed in context, including Article 4, Rule 2a. It's a context point. I'll develop it in a moment. Second, the master is singularly and exclusively responsible for navigating. Passage planning is navigating. And then third, owner's approach is consistent with precedent, such as there is. And there isn't very much we accept. Now, turning to the first reason, by this stage, we're at the scenario where the court has already decided that the vessel is unseaworthy. But what we say is all of the considerations that are important for construing Article 3, Rule 1 obligation of seaworthiness apply also to the scope of due diligence obligation, and when applying the critical question to passage planning. And these are the origin of the exception in favour of navigational errors, and the treaty's object and purpose in allocating insurance risk. All those factors you can take into account when construing the critical question, what does a carrier have to do? You're also allowed to look at precedent. This morning I was going to take you to the Oritani. I haven't done so, but it's in my written case. But also the Jalaviha. And the three, the Aristo, the Oritani, and the Jalaviha, the three American cases, all show, again, that navigation is out with the orbit of responsibility of the carrier. They all demonstrate that navigational decisions and subsequent errors are for the master's orbit of responsibility, not the carrier's. Now, as regards my second point, my second reason, we say that a master is singularly and exclusively responsible for navigation and passage planning. And we say the Eurasian Dream in particular demonstrates that where the relevant aspect of unseaworthiness involves matters which are within the singular and exclusive responsibility of the master, negligence in those matters will not amount to any lack of due diligence by the carrier. Now, we submit there's an analogy with passage planning between that and the Eurasian Dream. First, in respect of these two aspects of unseaworthiness, so crew incompetence or ex hypothesi passage planning, the carrier is not responsible for all of the steps involved in making the ship seaworthy. So for competency, the carrier is not responsible for the master actually reading the manual or the handbook, which he has been given, so long as there is adequate instructions and supervision. There are some steps which are outside the carrier's orbit of responsibility. This means that the carrier does not warrant, under Article 3, Rule 1, that the crew will in fact be competent, just as we say the carrier does not warrant that the passage plan will in fact be non-defective. And secondly, we say just as reading the instruction manual or getting enough sleep or not drinking too much is a matter singularly and exclusively for the master or the relevant crew member, so too are navigational decisions which are recorded on a passage plan. Passage planning is navigating, and navigating is singularly and exclusively for the master. It is innate to the master himself. And we say that that analysis is reinforced by the SOLAS regulations that I took the court to earlier today. It's also reinforced by the House of Lords decision in the Hill Harmony. There is one other case I'd like to briefly show you, which is another American case, which is the Portland Trader, which you will see at page 1639, tab 98. It's reported in the English Lloyd's Law Reports, the decision in 1962. Now, in that case, one of the allegations was that the carrier was negligent in failing to instruct the master to take a safer route, and it's a route between the islands of the Philippines. Now, that allegation of negligence or unseaworthiness was rejected. And it's worth looking at the general principle set out at 1639, and I'm looking at the right-hand column right towards the bottom of the page. It's about 8 or 10 lines up. Respondents did not attempt in any way to interfere with that decision. That's the route that was being taken. The evidence shows that the master traversed a recognised steamer route and had the same knowledge of the problems of that route as had the respondent. It is a general rule that where an owner has appointed a competent master, such owner is entitled to rely on the master's judgment in the navigation of the ship and should not be hampered and should not hamper the further exercise of his judgment with instructions and orders. That actually just reflects the section that I took you in the SOLAS regulations about Regulation 34 and 34.1. And if one turns over the page, you'll see they rely on a number of cases, one of which was the Oritani, which is another one I was going to take you to this morning, but it's set out in our written case. Because the owners in this case appointed a competent master whom they equipped with all that was necessary, they were also entitled to rely on him to navigate the vessel, which includes passage planning. my third and final reason why I say passage planning is not within, producing a non-defective passage plan is not within the orbit of responsibility of the carrier, is the Terepo case. Now, I accept that the researchers of all counsel in this case have not uncovered any case that is directly on point, but the Terepo comes closest to dealing with the point the court now is concerned with. And you'll find the Terepo I'll just give you the reference in a moment. Sorry. Find the Terepo at page 1527. Now, in the Terepo, a number of allegations were made against that the vessel was unseaworthy. And you'll find the allegations at page 1532. And one of the allegations was that it's under the particulars C, there was no or no proper passage plan for the part of the voyage during which the grounding took. And there was no passage plan is because the crew hadn't performed a passage plan for the relevant part of the voyage, and no proper passage plan because the pilots brought on their own passage plan, and that passage plan was said to be defective in 3 important material respects. And then by way of an amendment to the pleadings, you'll see on page 1533, paragraph 39, there was later on in the trial an amendment to the pleading that held that the master essentially was incompetent because he didn't know how to properly passage plan. And that's paragraph 39, C, just at the bottom of the page, on the right-hand column. Now, if one goes forward to page 1540, what happens is, at paragraph 96, Mr. Justice David Steele reviews passage planning, and he says the claimant's case on this topic was summarised as follows. There was no proper passage plan in place to assist the officers of the watch, encourage him actively to monitor the progress of the vessel. Claimants contend that this was because the master possessed a flawed attitude to passage planning in general and passage planning whilst under piloting. And then Mr. Justice David Steele says the starting point accordingly is to consider the quality of the passage plan contained on the pilot's large-scale charts on which the master and officer are relying. And essentially, in paragraphs 97, 98 and 99, he considers the 3 allegations of why the passage plan was defective, and he concludes that it wasn't defective. So can I say now I accept that his decision is obiter, because what he goes on to say wasn't determinative in the case. But, so in paragraphs 98 and 99, he says the pilot's passage plan was not defective. But then in paragraph 100, he says this. But let me assume in the claimant's favour, the passage plan was defective in one or more of the respects suggested. It was not in the event contended that this flowed from any failure of the defendants to provide proper systems, in the sense that the guidance and the instructions furnished by the owners were in any sense inappropriate. Section 5 of the Navigation Procedures Manual, equivalent to the one I showed you today in ours, was devoted to passage planning, including the requirement that the planning should include any passage through pilotage waters. Those instructions, taken with the additional publications furnished on board, such as bridge procedures, were agreed to be fully appropriate and sufficient. Pausing there, exactly in this case, my learned friend's expert trial accepted that all of our instructions to our crew in relation to passage planning were good and competent. And then at 101, the judge says, against this background, the focus of the claimant's attack became the newly pleaded allegation relating to the... Now, it is, I accept, difficult to know from the judgment whether, by the time it got to trial, the cargo interests were still maintaining that a one-off defective passage plan rendered the vessel unseaworthy. I was actually in this case, and I can't remember, it was nearly 20 years ago. So I'm not going to put my case too high. because it is ambiguous from paragraph 96. But the purpose, what I rely on here is if it was still being run that a one-off defective passage plan could render a vessel unseaworthy, well, paragraph 100 shows that Mr. Justice David Steele didn't think that that would render the vessel unseaworthy. Because what he does in paragraph 100 is assume that the passage plan is defective, but then goes on to say, but there was nothing wrong with all the instructions and the cruise instructions and the like, i.e. nothing, the owners had done everything they needed to do. So one way of looking at it is to say he actually determined that a one-off defective passage plan doesn't render the vessel unseaworthy. But in the alternative, even if it did, what he does do in paragraph 100, or certainly what it looks like he is doing, is he is saying even if it is rendered unseaworthy, the owners exercise due diligence by properly instructing the crew. And that is why in paragraph 101 he goes on to consider, therefore, let's look at competence. And what we do say is this does lend some considerable support to our submission, that the way in which a owner under Article 3, Rule 1 performs his obligation to exercise due diligence vis-a-vis passage planning, it shows that as long as you've given the crew all the correct instruction, all the correct equipment, you've given them all the correct instructions, they are competent, and you audit and supervise afterwards that they're following the instructions, that is all that a carrier needs to do. And if that analysis applied in the Terepa were applied to our case, the Libra, we say, either would have been seaworthy, her systems were adequate, or at the very least, my clients wouldn't be held to have failed to exercise due diligence. So in conclusion, the short point is that owners, we say, have done everything they could. In our case, they completely manned, equipped the vessel. In particular, the crew had detailed standing instructions on what to do in passage planning, which expressly actually required them to take into account dangerous or forbidden areas. I haven't taken you to that. But actually, if one looks in the instructions in our SMS, we say take into account dangerous, forbidden areas, safe distances from dangers, marked no-go areas. We did all of that. We say short of performing the task of actual passage planning themselves from their office in Marseille, my clients CMA are French and their main office is in Marseille, short of actually performing the exercise themselves, which owners could not legally do under SOLAS or practically do, there was nothing else owners could have done in this case. And therefore, we submit that this appeal should be allowed on that second ground if it were to fail on the first ground. Unless I can assist your lordships any further, those are my submissions.
Thank you very much, Mr. Hill. Now, you'll appreciate that as you've gone over your time by, I think, 23 minutes, we'll take that into account. We'll obviously have to allow a corresponding extension to Mr. Russell.
Of course. Mr. Russell, the lector.
Such a long time. Think about how I'm going to do this.
Yes.
My lords, my lady, we say that the owner's argument is wrong as a matter of law. Reason. And we'll explain why that is in court. And it's wrong as a matter of law, even if one seeks to look at the broader issues of general, matters such as master-pilot exchange and so forth, that my learned friend seeks to expand the case into. Even more importantly, for the purposes of the disposal of this appeal, much of his argument is divorced from the facts of the case. Because this is a case that involves a defective chart. It's not a case about deciding which way the vessel is going to go and planning the route that the vessel is going to take on the voyage. Still less is it a case about master-pilot exchanges and so forth. This case is about the failure, before the commencement of the voyage, to make the vessel's working chart safe for use in navigation during the voyage. We say that the key facts are as follows. When the vessel began her voyage from Xiamen in the early hours of the 17th of May 2011, the chart on the chart table was not safe for use in navigation. The chart was defective and unsafe for use in navigation because it didn't have the uncharted shallows warning marked on the chart. And it should have done. The judge found as a fact that it was inconceivable that a prudent owner would have allowed the vessel to begin the voyage with the chart in that defective condition, and therefore applying the very well-known and long-accepted test for unseaworthiness, he found that the vessel was unseaworthy. And because the obligation to exercise due diligence is non-delegable, the owners were liable for the master, the navigation officer's negligence in failing to mark the warning on the chart, and thus the owners were in breach of Article 3.1 of the Hague Rules. What I'd propose to do is to make those factual points good by reference to the key documents and the judge's finding of fact in the judgment, and explain a little bit around the judgment, what we say in relation to the facts. You've already been taken to the Notice to Mariners 6274P of 2010, and you've seen the warning on that, in that Notice to Mariners, that numerous depths less than charted exist within and in the approaches to Xiamen. And on the chart, there's obviously a reference to the Notice to Mariners, but not specifically the warning itself. And the warning itself is not on the base chart. And we can pick up the judgment at paragraph 24, which is at page 155 of the bundle. We see that paragraph 24 and following, the judge describes the passage plan, and it was comprised of the passage plan document with the coordinates and so forth written on it, and the working chart, and possibly also an under-keel clearance document that wasn't kept. And if we then move forward to page 162 in the bundle, at paragraphs 59 and following, the judge discusses a number of criticisms of the passage plan, and a number of errors in it, which, as it turned out, were not positive. But key is obviously paragraph 64, which is the discussion of the depths warning. And the conclusion at the end of paragraph 64 is as follows. The evidence in this case therefore shows that there ought to be placed on the working chart something which ensures that the navigator is aware of the danger created by the numerous depths in the approaches to Jamin, which are less than the charted depths. So it's an express finding that there ought to be placed on the working chart itself something which ensures that the navigator is aware of the danger created by the uncharted depths. And it's right that in the following paragraphs, the judge discusses the evidence and the competing ways in which that might have been done. And it's quite striking in this discussion about the warning. It's vividly brought home from the expert evidence the importance of having the warning written on the chart itself. Because in fact, Captain White, who was the owner's expert, wrote his first report without reference to the depths warning, which he subsequently agreed was of critical importance, because in looking at his version of the chart, he had seen the reference, or may have seen the reference to the notice to mariners, and appreciated the significance of that notice, because the warning wasn't brought home by that reference on its own. So the critical importance of the warning was illustrated not only by the master's ill-fated decision to leave the fairway, but also, in fact, in the process of the litigation itself. And having discussed the paragraphs 65, 66, and 68 and 9, the competing ways in which the warning could have been brought home by marking on the chart, the judge concluded at paragraph 70, firstly at the start of the paragraph, nevertheless, prudent passage planning required the danger created by the presence of numerous depths less than those charted outside the fairway to be noted on the chart. And then at the end of that paragraph, at the top of 165, said, my conclusion, having considered the expert and other evidence, is that whilst it would of course be prudent to note the warning in the passage plan, it would also be necessary and prudent to mark the warning on the chart, since that is the primary document to which the officer navigating the vessel would refer when making navigational decisions in the course of the outward passage. Now, just pausing for a moment, it's perhaps worth noting that the judge himself here does not use the language of correction or annotation, or say whether the note should have been marked in pencil or pen, or whether it should have been put there when the notice to mariners was received on board, or simply during the passage planning process shortly before departure. All that he is saying is that for the chart to be safe for use in navigation on departure from Jamin, the warning has to be marked on the chart. And the reason for that is quite plainly because the working chart is the primary, or one of the primary navigational tools that the master and those on the bridge will use when they are navigating the vessel on the way out of the port. It's their first point of reference. The master said in cross-examination that before taking the decision to leave the channel, he looked at the chart, as you would expect him to do. Why does he look at the chart? Because it's the chart that provides him with the information, or should provide him with the information, to navigate the vessel safely. The reason why he left the channel in this case was because his primary navigational tool, the chart that was sitting on the chart table, was defective. The reason why it was defective was because it hadn't been made safe for use in navigation before the voyage began. And then 73 is to the same effect. In the present case, neither the passage plan nor the chart contained the necessary warning. It was therefore defective or inadequate, and imprudently so. A source of danger when leaving Jamin was not clearly marked as it ought to have been. In that paragraph, he says, the passage plan nor the chart contained the necessary warning. It was therefore defective. Well, he's held that the warning should have been written on the chart itself. So when he says it was therefore defective, that is quite clearly an express finding that the chart itself was defective at the beginning of the voyage.
Because that was what passage planning required.
Yeah. Well, indeed, for the chart to be safe for use in navigation, the warning had to be on the chart.
He's looking at all this in the context of passage.
He is. He is. And the passage planning, we'll look at the guidelines in a moment. Passage planning obviously encompasses a number of stages, some of which are carried out. Well, appraisal is the first stage, which is a gathering together of the necessary information and ensuring that all the necessary information is available. Then you have the planning stage itself, which is the drawing up of the route and the translation of information such as turning positions and so forth onto the chart. And then once the voyage commences, you have the execution and the monitoring of the voyage.
Perhaps the clearest expression of it is at the top of page 165, the last 6 lines of that paragraph, where he says that the chart, he doesn't say it's not merely a passage plan, but he's effectively saying it's the primary document available on the bridge. Decisions about where to go.
Indeed, and that's why I say it's plainly a navigational tool. It's the primary tool that's used in navigation, and the master himself said it's the document that he looked at before he decided to leave the channel, and that's why it's critical that the chart is safe for use in navigation. In this case, critical that the warning was written on the chart. So having made those findings, the judge then goes on to consider on seaworthiness, and his conclusion is at 78, well, the initial part of the conclusion is 78, where he refers to the IMO resolution, saying that a well-planned voyage is of essential importance for safety of life at sea, safety of navigation and protection of the environment. And then at the end of that paragraph, he says, the appropriate warning in the passage plan and on the chart would serve to reduce the risk of poor navigational decisions during the passage. It seems to me inconceivable that the prudent owner would allow the vessel to depart from Jamin with a passage plan which was defective in the manner in which I have found. Inconceivable that the prudent owner would allow the vessel to begin the voyage in the state or condition that she was in when the voyage began. And at 79, he expands on that, and he notes at letter G, the presence on board a vessel of the appropriate chart is another aspect of the preparation for safe navigation. But the presence on board of the appropriate chart is also an aspect of seaworthiness. Further, where the Admiralty gives notice of a correction to the appropriate chart, a vessel will not be seaworthy unless the chart has been corrected. If the vessel's navigating officer fails before the commencement of the voyage to correct the chart, the vessel is therefore rendered unseaworthy. The correction of the chart is part of the preparation for safe navigation. A corrected chart does not cease to be an aspect of seaworthiness merely because its purpose is to assist in ensuring safe navigation. And then he refers to the soundings that had to be added from the other notice to mariners that you've seen, because such failure could have rendered the vessel unseaworthy at the beginning of the voyage. And then he deals with the argument that because that the production of a defective passage plan is in some way different. But when you look at that paragraph, and bear in mind that the purpose of passage planning is to ensure that there is in place a sound plan to prevent bad decisions being taken in real time, as it's put elsewhere in the judgment, then the idea that there is some material distinction between the choice of the right charts and the correction of the charts in accordance with permanent notices to mariners, and the marking on the chart of all the relevant material that makes the chart safe for use in navigation on the outbound voyage. There's no material distinctions there that can be drawn. It's clear that a prudent owner will not allow the ship to put to sea if it doesn't have all the documents in place to allow the upcoming voyage to be safely prosecuted. And there are a wide range of documents that applies to, and this can be seen in the authorities. Some of the documents will pertain to the legal ability to complete the voyage. Some will pertain to the proper management of the ship and the engineering side, so whether the crew and the engineering staff have the necessary plans, necessary instructions to enable them to operate the engines and the pipework and so forth. Some of the documents will pertain to the safe navigation of the ship during the voyage. But as a matter of law, all those categories of documents that have to be in place to enable the vessel to be safely prosecuted are treated in the same way. And if all the necessary documents are not on board and in proper shape, then the ship is unseaworthy.
There might be a distinction, there might be, between information we're dealing with here that ought to be recorded on the chart about depths and the sort of example that Mr. Hill was giving of what's essentially a provisional decision to travel at a certain speed.
There may be a distinction. It's a slightly different category. I would accept that. Our position is that obviously that doesn't need to be determined for the purposes of this appeal, because this is a case involving a defective chart. The answer, we say, is that one has to consider the purpose of the passage plan. And I say that the purpose of the passage plan is to stop bad decisions being taken during the course of the voyage itself. So rather than simply leaving the navigation to take place during the course of the voyage, what the regulations say, or the guidelines say, is you have to put in place, before the beginning of the voyage, a berth-to-berth plan. And that plan is much more than simply the recording of navigational decisions. It's the document, one of the documents, by reference to which the vessel is then navigated when she's on passage. So, that can be seen by reference to the execution and monitoring stages of passage planning. You have your plan that it is the vessel is intended to follow, and you use that as an aid to navigation when you're navigating on the voyage. It's obviously not set in stone. You have to review at all times what the right thing to do is on the water. But even in that case, you are using the document that has been produced as an aid to navigation and as a tool in navigation, because it sets out what has already been decided is going to be a safe way, or should be a safe way, to navigate the vessel. And the question was put by my Lord Briggs. Would a vessel be seaworthy if there was no passage plan in place? Well, in the current climate, it couldn't possibly be said in my submission that a vessel is seaworthy if there is no passage plan in place. Where the guidelines require a passage plan to be in place to prevent or to help prevent bad decisions being taken during the course of the voyage. And equally, therefore, if you have a bad plan that sets out a bad route and an unsafe route, the vessel is unseaworthy. Because, again, no prudent owner would allow the vessel to go to sea with a passage plan in place that is going to stand the vessel into danger.
Just going back to the emphasis you place on the chart, your argument would be the same, wouldn't it, if the judge had found the passage plan itself effective enough, and hadn't also found that it should have been on the chart?
Yes, it would be. If the tools that have been created during the passage planning process are defective because they don't contain the necessary information, then the vessel will be unseaworthy. It's perhaps more stark in the case of a defective chart, because it's very well established on the authorities, and it's conceded that a defective chart renders the vessel unseaworthy. And I mean, we may come to this when we look at some of the authorities. The question of whether a vessel is unseaworthy or not is essentially binary. Is there a state of affairs which makes the vessel unseaworthy or not? It doesn't matter for the purposes of unseaworthiness. It may matter for the purposes of due diligence, but it doesn't matter for the purposes of unseaworthiness, the process by which the state of affairs that creates the unseaworthiness, how that came about. So it doesn't matter if the working chart is unsafe, because a chart of adequate scale isn't on board, or the master and navigating officer have taken the wrong chart out of the chart box. If they haven't chosen the right chart, the vessel is going to be unseaworthy at the commencement of the voyage. If the chart hasn't been corrected by reference to notices to mariners, as my learned friend accepts, the vessel is going to be unseaworthy. There's no principal basis for distinction between the uncorrected chart that is unsafe and renders the vessel unseaworthy, and the chart in this case, which hasn't had the necessary information put on it, in precisely the same way as the uncorrected chart hasn't had the necessary information put on it. No ground for distinction between the uncorrect chart and the chart in this case, which is unsafe because it doesn't have the information on it which is necessary to enable the vessel to be navigated safely.
But is that really what you're complaining about, in the sense that the information was all there? What you're complaining about is that the master and his team did not mark up the chart in the usual way to show the notice to mariners. And if you go down that line, then you may be coming closer to Mr. Hill's position, that what you're really complaining about is something done by those responsible for navigation.
We don't say that the owners themselves failed to provide the vessel with material which they should have provided. But that is, one then looks at what is necessary to discharge the obligation of due diligence, which is a non-delegable obligation. There are any number of cases where the vessel has had all the material on board that is required for it to be operated safely, but the master or the chief engineer or whoever it is doesn't use the materials that he has properly. So if you take a case like the FJ number 2, for example, which is referred to in the judgments, that was a case where the master miscalculated the distance that the vessel was going to have to run,
bunkering,
and didn't take enough bunkers on board. So in that case, the master had all the material that is at hand that he needed to carry out a correct calculation as to the bunkers that he needed to have on board at the start. He failed to use those materials properly. He negligently miscalculated the route and miscalculated the bunkers that required. Answer: vessel is unseaworthy, and the owners are liable because they are liable on a non-delegable basis for the masters.
But that's not necessarily going to answer the point, because there it's a clear responsibility of the carrier to produce the bunkers. But here it's being said, masters do the marking up of the chart and the preparation of the plan, and the preparation of the plan is part of navigation, because you obviously can't get started on navigation until you've prepared your plan.
Yeah.
So it's a more detailed question than you.
Well, as between the carrier and the bill of lading holder, the shipping interests, in our submission, it's plainly within the carrier's orbit of responsibility to ensure that a proper passage plan is in place. Now, the responsibility for doing that is delegated to the master in the same way as in the IVJ2, the responsibility for calculating the distance to run was delegated to the master. Or take another example, in the Friso as an example. That's the case where the vessel was unstable because the master didn't carry out proper stability calculations and press up the bottom tanks. The responsibility for performing the stability calculations and pressing up or not pressing up the bottom tanks is left to the master. I mean, there's no suggestion that CMA and Marseille are going to contact the Libra to ask the master if the ballast has been properly distributed. So there's no difference in kind between those cases and this case.
But maybe their responsibilities are not exclusive, that the master is expected to do one thing, the owner is expected to do another, and you have to show the owner is expected to check the work has been done.
No, there's no requirement because we'll look at this when we look at the Muncaster Castle, which is it's important to look at and to fully understand the principle of non-delegability. The point is that, and this is expressly said in the Muncaster Castle and other cases, the work has to be carried out with due diligence, and it doesn't matter who carries out the work. The work itself has to be carried out with due diligence, and if it is the master or the navigating officer who is carrying out the work and they fail to exercise due diligence with the consequence that the vessel is unseaworthy, then there is a breach of 3.1. And there's no difference between those cases and the cases where a chief engineer fails to take a proper measurement with the result that there's a main engine breakdown. That's the Cape Bonny, for example, or the chief engineer has new lube oil but fails to change the lube oil with the result that there's a main engine breakdown. What one comes back to when it comes to the question of due diligence is that due diligence has to be exercised in the work itself. And what is the relevant work? Answer to that, the relevant work is the work that is necessary to make the vessel seaworthy at the commencement of the voyage. And if to make the vessel seaworthy at the commencement of the voyage, the warning has to be written on the chart, it matters not to whom the responsibility for doing that has been delegated. And it matters not that, as a matter of regulation, it's the master's responsibility, because the regulatory position and the allocation of responsibility as between carrier and cargo interests under the Hague Rules are two quite separate things. So it doesn't help to point to the guidelines or SOLAS and say, well, as a matter of regulation, the owners aren't able to interfere with what the carrier does. There's all sorts of cases where, as a matter of practicality, the carriers can't and don't interfere with what's happening on the vessel.
That wouldn't have been the case in 1924. There wouldn't have been this web of guidelines and regulation.
No, exactly, and therefore, for sure, if the making the vessel safe for navigation is a matter which the the carriers leave to the master, but they are responsible for his failure to do it properly.
But if there's something, just take it's not necessarily directly pinned into the facts, but if, as a result of the history of Admiralty, you then get and the way it evolves, you get a regulation which says the master is to be exclusively in charge of doing something, wouldn't that be taken into account in the interpretation of the treaty in some way? Because it's got to presumably apply as conditions change in marriage.
Well, the question is as between carrier and cargo, on whose behalf is the master doing it? And so, in my submission, that the task of making the vessel seaworthy is the carrier's responsibility as between carrier and cargo. That's what 3.1 says. The fact that there is another piece of regulation that says part of that task of making the vessel seaworthy is to be performed by the master, and the owners shouldn't interfere improperly with the master's exercise of the task. That doesn't alter the balance that is set out in the rules and the allocation of responsibility as between carrier and cargo.
But back in 1924, who produced the passage plan, the master or the owner?
Well, goodness, I'm not at all sure the extent to which passage planning, as we now know it, took place in 1924. But what you certainly would have had would have been a requirement for the vessel to be seaworthy, for the vessel to have the right charts, the best charts, and to have any information that was required for those charts to be safe in use in navigation marked on the charts. And, you know, it doesn't matter where, as a matter of fact then, obviously there's no evidence of this, it doesn't matter, as a matter of fact then, the extent to which owners were buying the charts before the voyage and handing them to the master, or giving the master the money to buy the charts himself. If the right charts weren't bought, then the vessel was unseaworthy. And again, as between cargo and the carrier, responsibility for ensuring that is done, that the work is done with due diligence, is allocated to the carrier, and it matters not who does the work. And certainly doesn't matter who is made responsible for that work as a matter of international regulation now, to the question of how 3.1 operates.
This is a historical argument, isn't it? It's a historical. It has to take account of the way in which this has evolved. Would I be right in thinking the master had an enormous amount of responsibility in the 18th and 19th centuries? Well,
certainly the further back you go, the greater the responsibility that the master had, and you know, matters are now increasingly are managed from shore, and you know, practices change all the time. But what doesn't change is the allocation of responsibility under the rules, as I say, as between carrier and cargo, for ensuring that the vessel is seaworthy. The vessel has to be made seaworthy. Due diligence has to be exercised to make the vessel seaworthy. And it doesn't matter who does the work, due diligence has to be exercised in the work. I see the time, so that would probably...
If this is a convenient moment, Mr. Russell?
It is, yes.
Very well then. We'll adjourn for the day and we'll resume the hearing at 10:30 tomorrow.